Hi everybody, Martin from Salvo Migration here. And in this video, I wanted to talk to you about a problem. The problem that we have at the moment really relates to the common question that we get, which is how do I qualify for my permanent residency or my citizenship to Australia? Now, as you might know, and as you might have experienced, there's been a lot of dramatic changes to visa options and visa pathways to Australia within the last 12 months. And what it's causing is a really dramatic decrease in options that will eventually transition or qualify you for PR. Now, if you are on a temporary visa at the moment, statistics tell me that you are either here on a student visa, a working holiday visa, or perhaps a tourist visa. Statistics say that the majority of temporary visas granted to Australia will be one of these three, unless you are a New Zealand citizen here on a very specific visa type for yourself, or another less common temporary visa. But statistically, from a majority point of view, these three visa types would make up the vast majority of temporary visas held or approved to visit and to stay in the country temporarily. Now, the problem is that these visas are only temporary. So commonly, visa holders will try to find a visa that will eventually qualify them or transition them to the residency. Now, before the changes, the three most common streams of visas that were used to qualify for PR were if you were sponsored, if you were a general skilled migrant through the points test, or if you were the relative of an Australian. And I'll say family, but more specifically, I will clarify and say that I mean partner and I mean parent, in the sense that you are either the partner or the parent of an Australian citizen or permanent resident. So with the changes that we saw or have seen in the last 12 months, it's really been focused towards limiting and narrowing the options available for sponsored visa pathways. So what we've seen is the abolishment of the 457 or the replacement of the 457 with the TSS, and the increase in requirements for the other two sponsored visas, which are the ENS and the RSMS. Now, there's been a long list of changes that have really affected these three visa types, but I suppose the key change, or one of the most important increases, is that all three of these visa types now require what the department is calling, post-qualification work experience in order to apply for one of these visas. So let's say hypothetically that you're here on a student visa. You might have completed, a certificate 3, maybe you've completed a cert 4, maybe even you've completed a diploma or a bachelor or a master's, whatever it is that you've come in to study. You might have been on multiple student visas. You might be on your second, your third, maybe even your fourth student visa, having, studied a variety of these different types of qualifications, trying to find the right combination of qualifications that will eventually allow you to apply for a longer term visa. The issue is that the changes that we have seen is that for you to be sponsored under the TSS, you now require 2 years of full-time work experience in the occupation or in a related occupation to what you're being sponsored under. And similarly with the ENS and the RSMS, which these two are permanent visas, the 457 and the TSS were and are a temporary visa, require 3 years post-qualification full-time work experience. So as we can see, the ENS and RSMS, because they're permanent, they have a bit of or slightly higher requirement in 3 years. But even the 2-year requirement for the TSS is proving to be a challenge. And the reason that it's proving to be a challenge is that if you are on a student visa, as you know, most likely is that you have part-time work rights, which is 40 hours a fortnight, 40 hours. And therefore, it's very difficult for you to accumulate 2 years of full-time worth of work experience whilst you're studying and working part-time. So what we're finding is that a lot of international students or recent international graduates, once they finish their qualifications, just don't have the work experience requirement or don't meet the work experience requirement to be sponsored for the TSS, and certainly not for the ENS or the RSMS. You know, the ENS and RSMS are just out of the question for international students. The only real option potentially would be the TSS. But that 2 years is proving to be an issue. If you are an international student trying to be sponsored and you're trying to find ways to meet this 2-year requirement, there's only really 2 suggestions that I can give you. One is that the law doesn't necessarily say that your work experience needs to be post-qualification. This is really an internal instruction from the Department of Immigration, or Department of Home Affairs, as they call themselves now. So the law doesn't specify that your work experience has to be post-qualification. It also doesn't necessarily specify that it needs to be full-time. But this is really the line that the department are running with. But if we were to look at the law strictly, there may be room for you to be able to use 2 years of part-time work experience whilst you're studying in order to meet the requirements. But chances are that if the department are the ones that are specifying 2 years of full-time work, and if it's the department are the ones that are specifying that the work also needs to be post-qualification, chances are you're going to run into a refusal at the Department of Immigration when you submit your TSS, and it's going to have to be appealed. You're going to have to appeal the refusal and then fight your case at the tribunal, at the AAT. Now, the AAT can be more lenient, or I suppose assess things in a bit more of a legal sense, in the sense that they will mainly rely on what the law says and not necessarily what the department internal policy instructions are. Meaning that you have a chance. There is an argument, in my opinion, that if you were to be refused at the department level when you apply for your TSS visa for only having been able to rely on 2 years of part-time work experience or 2 years of work experience that was before a qualification, there is room there to argue with the tribunal. Also, keep in mind that assuming you were to appeal a TSS refusal, the time that it would take for the tribunal to open your case, your hearing, could realistically be 12 or more months away. During that time, you can continue to accumulate more work experience on the visa that you may hold at that point in time, which might be a bridging visa while you're waiting for your appeal. There's nothing in the law that says you can't use work experience gained whilst waiting for an appeal on the bridging visa. So by the time you get to the tribunal, if you've been able to accumulate 2 years of work experience, preferably full-time and preferably post-qualification, there is certainly an argument there to be made to the tribunal. And in my humble opinion, I think you have a very good chance of winning because, like I said, the tribunal will look at what the law says, not what the tribunal want it to say. So that's, I suppose, one pathway. The other is for those international students that qualify for their 485 graduate visa, which is an 18-month to 2-year, let's say on average, length visa after they complete their studies. Whilst you're on the 485 and working, hopefully, in your position, in your occupation, that gives you an opportunity to accumulate 2 years. But let's say you're on the 485 or the 485 is expiring and you still haven't accumulated your 2 years worth of work experience. Similar to the pathway I just mentioned, if you were to apply for the TSS and be refused on the basis of your work experience, there is, again, the option of appealing the refusal and continuing to work whilst on your bridging visa waiting for the tribunal hearing, and then arguing your case at the tribunal level that at that point in time, in 12 months' time or however long it may take, that at that point in time you have then accumulated the required 2 years of work experience. So that to me are 2 potential solutions to the 2-year work experience requirement if you're an international student or if you're a 485 visa holder. However, there are variables and there are unknowns. Unfortunately, because the TSS visa is so new, we don't have any precedent, we don't have any examples as of yet in terms of how the tribunal will assess this 2-year work experience requirement. However, in my experience and looking at how they have interpreted similar requirements in the past, I certainly think that there is room to argue at the tribunal level. So that's, let's say, applying for a sponsored visa and trying to deal with the TSS requirements. So because it is so complicated and because it is very uncertain, a lot of people have now been funneling themselves or transitioning to trying to apply for a general skilled migration visa through the points test. And what I'll just add here is that whether you're here on a student visa, a working holiday visa, or a tourist visa, the requirement for you to have these work experience amounts before being sponsored are the same. So you may be on a working holiday visa, and you may face the same issues as not meeting the work experience requirement to be sponsored. So chances are you're looking at an alternative pathway, and in all likelihood, that's probably applying through the points test through the GSM visa options. Now, in terms of the options that exist in this pathway, we have the 189, we have the 190, and we have the 489. Now, these first two visas are permanent, and this is a temporary visa that will eventually transition to an 887, which is a permanent visa as well. So the effect of the increase in requirements for sponsored visas means that there's more and more people applying for a general skilled migration visa or looking into GSM visa options. And what that is causing is that the minimum points that you are required to have a realistic chance of being invited for any of these visas is continuing to increase. As of the most recently available department statistics, we're seeing that to be eligible for the 189, which is the most preferred or preferential general skilled migration visa, you're looking at requiring around 75 points. With the 189 and the 489, the 189 is what's called a state-nominated option, which means every Australian state has their own list of occupations that they're willing to nominate for, and each state also has their own requirements for every specific occupation. So you may find a state that has your occupation on the list. Let's say hypothetically a cook. You can find states that are looking for cooks, but the problem is that the states can specify their own requirements. So they may be looking for cooks. However, they may specify that you need to have a job offer in that state as a cook, or that you need to be already working in that state as a cook, or be residing or living in the state. So that there are a range of requirements that states can impose before they'll even consider your application for the 190. Nonetheless, it is still an option. And because of the points increase for the 189, there's more and more people applying for state nominations for the 190 and the 489. So what we're finding is that the states are continuing to increase their requirements because they're filling their quotas faster. There's more and more people applying to the states for these options, which means there's less and less positions available, and the requirements and the process of applying for state nomination continues to become more difficult, and the requirements continue to increase. And we're also finding that some states are starting to stop accepting. That's obviously not a little state there, but it's part of my diagram. The states are starting to close in the sense that they're reaching their capacity. Now, thankfully, it's the beginning of the new year, let's say the beginning of the new program year, and states are starting to reopen as their quotas reset. However, in my humble opinion, I think that we will find that the states will close and reach their quotas very, very quickly this program year. I think it's going to be the fastest in this program year that we have ever seen that states will reach their maximums or stop looking for more and more applicants. So fundamentally what that means is that the 189 is very difficult to qualify for with the points requirement, and the 190 and the 489 are also starting to become more and more narrow as the states become pickier and pickier. There are still options in terms of if you have family that lives in certain regions in certain states, you might be able to apply for the 489 as a family relative. But similar to the 189 and the points required for the 489 family nominated stream is also continuing to increase, and only the very, very high scoring are being nominated. So even just having family in the right region, in the right state, is not necessarily a guarantee. So because of all this, we're now finding that more and more people are starting to apply for partner visas. And this is very easily reflected in the processing times. So we are finding now that partner processing times are anywhere from 24 to 30 months, which is almost unbelievable when you consider it, and especially when you consider that, let's say 3 years ago, the average processing times were maybe 6 to 9 months. But to me, this is a very key statistic that shows me that all this really is a domino effect. As sponsor visas become more difficult, more people are funneled into GSM. As GSM becomes more difficult, more people are funneled into partner visas. And because there's more and more people applying for partner visas, the processing times continue to increase. And in my humble opinion, unless we see a change here, the partner visa processing times will most likely continue to get longer. So this is a honest breakdown and an honest overview of the current migration system and the current problems that people are finding in staying in the country on a longer term basis if they're here on a temporary visa, or even if you're overseas and looking for ways to come in and eventually qualify for your PR. Just the advice that I would give you is just be cautious, be aware that things are not as straightforward as they used to be. That doesn't necessarily mean, I'm not necessarily saying that you need to go and speak to lawyers and agents to find ways. What I would say is just be cautious of agents and lawyers that say that they can find you a way, because as I hope this diagram has shown, it's not necessarily as straightforward as they may make it out to be. So look, I hope this has been helpful. I hope that it shed some light and might answer some questions that you had. If you do have any more questions, please feel free to get in touch with us at Salvo Migration. You can leave an inquiry online and we'll do our absolute best to get back to you within 24 hours. Thank you very much.